employee and you as an employer, as long as you are engaged in any of the contract of employment between an employer and an employee, that means you have the capacity to employ someone into your establishment, or you are being under someone who pays you salary at the end of the month under a contract of employment. This topic today concerns you, and it's a very interesting one which arose as a result of a recent decision of a court in Nigeria, and that is what has prompted our discourse for today. So sit tight and let's get ready for classroom. Our today's topic is: must there be a reason to terminate contracts of employment? Must there be a reason to terminate contracts of employment? We'll start with a story. It has been a long time since we said the story on this program. So we'll start with the story today. Our story concerns Mr. Ojo. Mr. Ojo happens to be a marketing personnel of Emmanuel Communications Limited. During the end of the year party held on the 22nd of December, Mr. Ojo had a little quarrel with Mrs. Bamidele, who happens to be the managing director of Emmanuel Communications Limited. Now, it was just a slight altercation that did take up to 2 minutes, and Mr. Emmanuel, Mr. Ojo rather, though he felt annoyed that Mrs. Bamidele talks to him in such a derogatory manner, in such a disrespectful manner, not minding that he has put in so much work into the company for the past year, which led to their productivity for that very year. So they went home, went for the Christmas, enjoyed the Christmas, the New Year. On the 2nd of January, when they are supposed to resume on the 4th, just on the 2nd of January, immediately after the New Year celebration, Mr. Ojo got a short message, SMS, from Emmanuel Communications Limited, which stated and read thus: "Dear Mr. Ojo, your services at Emmanuel Communications Limited is no longer required. You shall return all properties of Emmanuel Communications Limited in your possession on or before 4th of January 2023. Mr. Ojo is confused. What must have arisen this or prompted this termination of his contract of employment? Why? And then he approached his friends, and his friends said they didn't state the reason why you were being sacked, and as such, that termination of contract is invalid. The question is that termination of the contract of employment invalid in law? Now we have to understand what amounts to termination of contract of employment. Termination of contract of employment goes in 2 ways. It's not just when you are being given a sack letter, as we call it in local parlance, that amounts to termination of contract of employment. Also, when you tender your resignation, either by spoken words or in writing, that equally amounts to termination of contract of employment. So it's not only the employer that can terminate a contract of employment, but also the employee can terminate his contract of employment voluntarily. Now, let's bring it down to our topic for today. That is to say, must there be a reason for an employer to terminate his contract of employment with the employee? Or must there be a reason for an employee to terminate his contract of employment with his employer? Now, as I said, this discourse was prompted by a recent court judgment delivered on the 20th day of November 2022 by the National Industrial Court of Nigeria between the case of Godwin versus Unity Bank PLC. Now, this question was raised. Mr. Godwin was issued a sack letter, as we call it in local parlance, and it simply stated that his services is no longer needed in Unity Bank Nigeria Limited, PLC rather, and he went to court challenging such termination as being invalid, as it does not conform with global best practices of termination of contract of employment, which provides that you must state a reason for it. Now, having stated that, let's just take it out from there. Now, under the termination of contract of employment convention of 1982 by the International Labour Organization, that convention states that it is inhumane, it is unconscionable, it is repugnant, it is unlawful for any employer to terminate the contract of employment of his employees or employee without stating reasons for terminating such contract. Because before you employ the person, you had reasons for employing the person. Okay? Because you believe the person has the capacity to do A, Y, B, C, D. But so at the point of terminating his or her contract, you should equally have reasons to terminate his or her contract based on reasons A, Y, B, C, D. And that is why the convention, which is the Termination of Employment Convention of 1982, provides that you must provide reason as an employer before terminating the contract of your employee. And it is based on that the National Industrial Court, in the case of Godwin against Unity Bank PLC in 2020th of November 2022, held that the termination of the contract of Godwin, Mr. Godwin, without stating a reason by Unity Bank PLC is unlawful, it is repugnant, it is void, and Mr. Godwin should be reinstated as an employee of Unity Bank PLC, and all his remuneration from the point of his termination of employment, which was in 2014, should be paid to him up to 2022. Now, is that the correct position of the law as it is today? It is interesting to note that the appeals from the National Industrial Court ends at the Court of Appeal. It doesn't go to the Supreme Court. This is by virtue of Section 254 sub C of the Constitution, which creates the National Industrial Court as a special court on labor and industrial matters. Now, the Court of Appeal has given down a laid down principle when it comes to termination of contracts between employers and employee. And it's interesting that in a previous case, which is the case of OAX Pensions Limited against Oladipo, the Court of Appeal stated there that though it is provided under the Termination of Employment Convention of 1982 that for you as an employer to disengage your employee, you must give reason for that disengagement in your contract of employment. What brought parties, that is the employer and the employee, into the contract is the contract of employment document. And there in the document, it is usually written that where any of the parties, that means either the employer or the employee, intends to terminate this contract of employment, such a person must give 1 month notice or 2 months notice to the other party before terminating the contract of employment, or shall give 1 month salary or 2 months salary in lieu of notice. Now, what this means is that if an employer wants to terminate the contract of his employee, that employer must give notice to the employee, at least 1 month notice to the employee before the date of termination of the contract. Or in lieu of that very 1 month, instead of giving him the 1 month notice, you can now decide to pay him 1 extra month of his salary in replacement of that notice, and that suffices. And because that is a contract between the employer and the employee, no other thing, no other law should govern that contract except the agreement of parties. That is what we call a law, pacta sunt servanda. That is, parties are bound by their agreement. And that the Court of Appeal heard there that if that is the agreement of the parties, then that termination of contract can only be governed by that contract of agreement and not the termination of employment convention of 1982. Secondly, that the termination of employment convention of 1982 is a foreign treaty which has not conformed with the provisions of the Nigerian Constitution to make it enforceable in Nigeria, because a foreign treaty, for it to become enforceable in Nigeria, it has to be domesticated. By that we mean the National Assembly must pass it as a national law to govern Nigerians, and it becomes not a convention, not a treaty, but now an act of the National Assembly of Nigeria. This is because Section 12 of our Constitution, the 1999 Constitution, provides that no international treaty shall have any force of law in Nigeria except such treaty has been ratified by the National Assembly and made an act of the National Assembly to operate here in Nigeria. The question now is, has the termination of employment convention of 1982 adopted and domesticated by the National Assembly to make it an act of Nigeria so as to be enforceable amongst Nigerians? The answer is no. And because it has not yet been domesticated, it is not a law that is enforceable in Nigeria, and it cannot guide the relationship between employers and employee. In conclusion, as it stands today, Mr. Ojo having been issued a text message which simply said that his services is no longer needed in Emmanuel Communications Limited, and he should return all properties of Emmanuel Communications Limited back to the company before 4th of January of the next year. He is bound to comply, as his contract with Emmanuel Communication Services is terminated, and Emmanuel Communication Services need not to give any reason to terminate his contract. And that is because of the common law principle that he who has a right to hire has a right to fire. Having explained this, I believe you are now well abreast that even though the National Industrial Court wants to bring some form of sanity and respect for employees who are to be their contract is to be terminated, that is to say, an employer should give reason why he or she wants to terminate the contract of employment of an employee, even if that is the good intention of the National Industrial Court. As of today, that intention has not manifested into becoming a law in Nigeria, because that intention is a flow from an international convention that is yet to be domesticated in Nigeria. And until it is domesticated, the law today is that as an employee or as an employer, you don't need to give your employer a reason to resign, and as the employer, you don't need to give your employee a reason to sack him or her. Harsh as it sounds, that is the position of the law as it is today in Nigeria. I believe with this you are well abreast with the position of the law on whether reasons should be given by an employer who wants to terminate the contract of employment of the employee, or reasons should be given by an employee who wants to tender his or her resignation letter to the employer. And now you know that they don't need to give any such reason, either to resign or for the employee to be sacked by the employer. Please do well to leave a comment with us, or ask us any question, or make any suggestion on how we can serve you better in law assets through this radio program. So leave your comments, questions, inquiries and suggestions on the comment section on whatsoever streaming platform you are listening to us from, whether Facebook, YouTube, Ascent Radio itself, or X app. And as usual, we will always give you prompt response. Do wait to go to our website www.lawaccent.com. Click on the resource icon and you will see the article on today's topic so that you can read further and know what the law provides with respect to this topic for today. Until we come again your way next week, remain blessed, and as we say here in Law Assets, keep praying for Nigeria and keep the hope alive. Thank you and God bless you.